We'll now call the second case on the morning docket, 118790, in the matter of JSP.
May it please the court, JSP appears signed through counsel Michael Duma. I would request 3 minutes for rebuttal, please.
3 minutes is granted. Thank you.
Thank you. Your Honors, JSP is a juvenile offender subject to an EJJP prosecution. He was arrested when he was 14 years old for 3 separate offenses that he was charged with in 3 separate cases. When he was 14, when he was arrested, he had no prior criminal history, had never been arrested before, had never been part of the juvenile justice system whatsoever. These 3 cases that he was arrested on and charged separately on all included felony allegations. He pled no contest to all 3 of these cases as charged, and the deal was that the state would not seek to revoke or to waive him to an adult status. And in exchange, he would agree to the prosecution under an EJJP prosecution. He was sentenced pursuant to the EJJP statute to a juvenile sentence and an adult sentence. He was sentenced to 72 months in the juvenile correctional facility, which was an upward departure that he agreed to, followed by 24 months of conditional release. As well, he was issued an adult sentence of 237 months in the Kansas Department of Corrections, which was the judge essentially running each of the cases and counts consecutive to each other. Now, for someone who came into the system on his very first arrest with no prior criminal history whatsoever, no treatment, JSP had all of these cases because they were charged separately, act against each other to enhance his criminal history to make him a category A for each of the cases. This put him, made a tremendous sentence hanging over his head of 237 months for someone who'd never been in trouble before.
Just point of clarification, the offenses occurred when he was 14 years old?
Two of the cases included offenses when he was 14. One of the cases included an offense that occurred when he was 13. And that was one of the aggravated assaults that he was charged with. Nevertheless, all of them were waived to EJJP status. He was told by the judge at sentencing, and we concede, that a single violation of his juvenile sentence could cause him to serve his adult sentence. What I would say, though, is when he was released from the juvenile correctional facility after serving the first portion of his sentence there, he did perfect while he was in that facility. And he did very well even after getting out of the facility and being on conditional release for a period of time. When he was released from the juvenile correctional facility, he was handed 3 separate contracts. And these contracts I refer to in my briefs. One is from the Unified Government, one is from the Kansas Department of Corrections, and one is from Johnson County Department of Corrections. Now, these contracts, which were signed by the judge and incorporated as part of his juvenile sentence, and that which he is alleged to have violated to bring him here today, contain certain advisories that are obviously intended for people who are not EJJP status. They are advisories in these court orders that say, if you violate your conditional release, there are certain punishments which you may be subjected to. They include modifying the terms of your probation, sending you back to the juvenile correctional facility, basically the different sentencing alternatives that would have been available to someone who was just a regular conditional release violator or a regular juvenile probationer, not one that was subject to EJJP prosecution. The primary and important difference of an individual subject to EJJP prosecution is that when your juvenile sentence is found to be violated, there is an automatic imposition without discretion of the adult sentence.
You're kind of arguing, it seems to me your approach here is to argue fairness of this proceeding. We're here about jurisdiction, and the Court of Appeals said that you didn't have jurisdiction to bring an appeal. Could you address that for us, please?
Certainly, Judge. And part of why I speak of these contracts and these sentences that were essentially modified when he was released from the juvenile correctional facility is because I believe they vest jurisdiction in this court as a appeal of a sentence pursuant to KSA 382380 subsection B. In JSP's, under the unique facts of this case, his sentence wasn't necessarily handed down when he was sentenced back in 2011. His sentence came incrementally and was modified when he was released from the juvenile correctional facility. And so I think that because it is these modifications of his sentence that he complains of.
What's the modification?
Well, the modifications were to add specific provisions that you must not do this, you must not do this, you must obey your curfew. And there were 3 separate contracts which each contained their own conditions in which in some aspects contradicted one another.
Have we ever called probation conditions modification of a sentence before?
I don't know what that we have, and I don't know that I'd call them necessarily probation conditions because he wasn't on probation. He was subject to an EJJP sentence, which allows the judge to impose certain conditions on the release from JCF. And I would argue that those conditions are part of his sentence by virtue of the fact that it is those conditions that he is alleged to have violated his sentence, which caused his adult sanction to be imposed. And so my first argument would be that if not for all EJJP offenders, that JSP be allowed and that this be qualified as the appeal of a sentence, because he is in effect complaining about the provisions in the orders of the court that became part of his sentence that he was later violated as a result of not complying with. If this court is not willing to extend jurisdiction pursuant to that statute, my secondary argument is that the plain language of KSA 382347 subsection E and in connected to our adult criminal code, the plain language of those 2 statutes read together provides jurisdiction. Subsection E provides that, and I'm paraphrasing, but it gives juveniles who are subject to EJJP enhanced rights, and it gives them the right to trial by jury, a right to the assistance of counsel, and it says the right to all other rights in the Criminal Code of Procedure. That's crystal clear, and we know what the rights are in the Criminal Code of Procedure. That's crystal clear too. So if we follow the language of 2347E and reference the corresponding statute in the Code of Adult Criminal Procedure, which I believe is 223602, it provides that a defendant, as a matter of right, may appeal from any judgment. And I understand that this court has never exercised jurisdiction in these cases pursuant to this statute. This is a case of first impression, and the only citation to any jurisdiction that I see in any of the cases that deal with EJJP are from ADT, and in ADT, in re ADT, the court cited that jurisdiction was proper pursuant to 223601, which is an adult statute in the Code of Criminal Procedure. To get to that statute, I would argue that ADT had to use the provisions of 382347E to get to the Adult Criminal Code to find that there's jurisdiction in that case. I'd ask that you do the same thing in this case. I don't think we need to go into legislative intent because the clear and unambiguous language of the statutes say that a juvenile has a right to appeal all adverse rulings subject to EJJP. So That's my argument, Your Honors.
Mr.
State
Duma,
argues.
I wanted to ask a question about the issues you're actually trying to get raised, because you're trying to get jurisdiction over certain specific claims, and one of the claims is an Eighth Amendment claim, right?
Correct.
In KSA 382380, subsection B2B, which the state has noted previously in their briefs, it says that there will not be review of any sentence resulting from an agreement between the state and the juvenile which the sentencing court approves on the record. Isn't the challenge on the Eighth Amendment itself a direct challenge of the sentence that in this case resulted from an agreement approved by the court?
I don't know that the sentence issued in this case was by agreement. The prosecution for EJJP was by agreement. The sentence, and if you look at the record at sentencing, there was no agreement as to what the sentence would be. The counsel argued over whether it should be consecutive or concurrent. And so I would argue that I'm not barred by that, because although the EJJP was consented to, the sentence was not agreed to. I'd also argue that the Court of Appeals found that the state had waived any argument that our appeal is otherwise barred by virtue of failing to raise that.
But isn't it a jurisdictional question and therefore something that can be raised at any time?
I think the Eighth Amendment issue is yes. A jurisdictional issue that could potentially be raised at any time.
Well, I mean, the bar to it can be raised at any time, too. The fact that we don't have jurisdiction under the statute, arguably, and I understand you have an argument that doesn't actually apply, but if it does, I don't see how the state could waive the ability to raise that because it's a question about whether the court has jurisdiction.
I think this court could find sua sponte that, or not sua sponte, but on its own, that jurisdiction is divested on that ground. I think it's possible. I think you'd have to overrule the Court of Appeals in their direct finding, because they did say that the state had waived that, and they may be wrong in that regard. But I would argue that it was not an agreed sentence and it's not waived on that basis. Any other questions?
questions? Thank you.
Thank you.
Madam Chief Justice, may it please the court, the state of Kansas appears by Assistant District Attorney Daniel Obermeyer. Your Honors, I'm asking this court to affirm the Court of Appeals for 3 reasons. First, the Court of Appeals did not err in finding that KSA 382380 does not confer jurisdiction for a court to hear the imposition of an adult sentence in an EJJP case. That was a correct ruling on their part. Second, KSA 382347 does not confer additional rights of appeal to juvenile offenders subject to EJJP. The plain language of the statute does not permit that, nor does any statutory construction which this court can put on.
What remedy does a juvenile under the JEEP have if the procedure is flawed that determines that he committed offenses while on post-release that would, or did something that would trigger the adult sentence? You're saying there's just no appeal right at all? That's just set? I mean, the court could not find any reason? I mean, there's just no remedy at all? That's your position?
Outside of what this court has repeatedly held, that jurisdiction for appellate rights is purely statutory. And the fundamental rule of any statutory interpretation is that the plain language governs. So if the legislature does not confer rights of appeals for imposition of an adult sentence, then no, I would say this court does not have any jurisdiction to review that.
There's just no mechanism for review at all. So it can be as egregious as I don't care if you didn't commit something, I'm going to find that you did, and just some sort of outrageous or conduct or whatever the trial court did to find, there's just no remedy at all for a juvenile in that situation.
I can only say through 382380 there is not. If there are any other remedies,
Well, talk about 2347.
certainly.
Why doesn't that give jurisdiction?
My argument first is that the appellate rights are for juvenile offenders, which includes those under an EJJP sentence, is specifically laid out in KSA 382380. So outside of that, we're not dealing
Well,
with
is that true? I mean, you're arguing plain language, so let's look at the language.
certainly.
All I read is the juvenile offender may appeal from an order of adjudication or sentencing, or both. There's no exclusionary language. It's permissive. It's saying the offender may appeal from these orders. And you're asking us to, and what the Court of Appeals did is presume that means and no others, no other orders.
Well, that would be a plain reading of the statute. It's
It
not-
might be if we didn't have 2347, but we do have 2347.
Certainly.
I just am having a hard time understanding your argument that 2347 is irrelevant to this case.
First, as I argue in my brief, if you interpret 2347 to mean that juvenile offenders under EJJP or waived to adult have these additional appellate rights, then that generally renders 382380 meaningless. Because why would you even have that statute laying out specific appellate rights if they're just getting all the rights which are afforded to adult offenders in the first place?
Because at least some of them are unique to the juvenile procedure, aren't they? Doesn't 2380 talk about the decision to put them in that process in the first place as being appealable?
Yes, that
That's
is.
not applicable to an adult offender.
Yes, but clearly the sentencing and adjudications clearly are applicable. Well, adjudications not so much, but convictions, it's
Right.
fundamentally the same thing.
I mean, it
So-
sounds like, it looks like it maybe does both, that it affords them some appeal rights that are available to adult offenders, which I agree seems like surplusage, but part of it isn't, right?
Well, correct. I'd say the first subsection wouldn't be surplusage, but subsection B, which I would argue in this case is even the more important subsection that we're talking about, that would render that surplusage. To go back, I'm sorry, Justice Stiegel, did I answer your question?
Well, I think so. Just to follow up quickly, though, you would agree that the right to appeal from any judgment is one of the rights that a criminal defendant has under the Kansas Code of Criminal Procedure.
Absolutely.
And 2347 does say that this defendant shall have that right. That's what the plain language says. You're just arguing that the more specific statute somehow trumps and stands on top of this.
Yes, and I would argue that because it is designated appellate rights of juvenile offenders, excuse me. And also, if we look at what's listed in that subsection of 382347, this is dealing with trial rights. So if we're looking at...
So if we follow, if I accept that portion of your argument, we would at a minimum have to conclude that these two statutes contradict one another.
At a minimum, yes. If this court does find ambiguity between the two statutes, then you have to resort to the
Then we
canons.
wouldn't some of our canons like rule of lenity, et cetera, kick in here to find jurisdiction?
Well, the appellant did not argue rule of lenity.
Well, we're here on
Certainly.
a jurisdictional question. It seems to me that's a question of law, and we ought to get it right, regardless of what the arguments are.
Certainly, but I would refer to Justice Johnson's opinions in the In Re DMT case. This court, when looking at the juvenile offender code, it doesn't have to parallel precisely the Kansas Code of Criminal Procedure. The appellate rights are purely statutory, and the juvenile offenders, even if they do have an EJJP sentence, are still juvenile offenders within the meaning of the code. So the more specific statute is 2380. So I would say that 382347 operates to ensure that they have these other trial rights, but that does not go beyond that and then confer additionally appellate rights. Those are specifically limited by 2380.
Counsel, if I could follow up on Justice Stiegel's question about Section 2347. Assume for a moment that it does apply, that we reject the argument that it doesn't and we apply it. this would be, the order to revoke and now impose the stayed sentence would then be an appealable judgment.
That depends on if you apply 2380 or not. To your earlier
I understand, but if we're applying 2347,
Right. And my argument to that would be then, I still think that's where you look at 2380B. And your question earlier to counsel about this is an agreed to sentence, does it still, is it still an appealable order?
well, but that would only wipe out the court's ability to review the Eighth Amendment issue with regard to the sentence. It wouldn't necessarily eliminate the ability to review the due process argument that's been made that by giving this person, when they left, all of these completely misleading advisories about what the possible sanctions were for violating their release, rather than mentioning the nearly 20-year sentence that would actually be imposed, violated due process. There's nothing in the statute you've cited that would eliminate the review of that due process argument, is there?
If you take the view that it automatically confers all the appellate rights which adult offenders have,
Correct.
I have a harder argument to make there. And
But you have no argument at that point, right? If 2347 applies.
that's why it's harder, yes.
Thank you.
Because the topic completely disappeared. Counsel, I have another question. We started interrupting you before you got to list your three reasons, or your three arguments. Do you want to tell us what the third one is now, or have you covered it?
Well, I tried to shoehorn it in there with the.
I wanted to be sure I caught it.
If you look at KSA 382380, my position is this was an agreed to sentence. The plea agreement was followed by the court. While there was not an agreed to number of months, fundamentally.
What do you mean agreed to sentence? How can you agree to a sentence when you don't know what the sentence is going to be? I mean, what did they agree to?
Well, the exchange was basically the JSP would agree to an EJJP sentence. He would agree to whatever adult sentence that the court would impose. He knew that the potential sentence he could receive. The parties, there wasn't much argument, if my recollection is correct, at sentencing as to what the sentence should be, the adult sentence should be in this case. There was a specific agreed to term of months, I believe, for the juvenile sentence, but not for the adult portion of the sentence.
You're saying that he understood, a 14-year-old understood that suddenly these three crimes would aggregate into a criminal history A and result in a 20-year sentence.
All of this was made perfectly clear to him. And Justice Rosen, I want to go back. I haven't focused on the facts of this case because we're dealing with a jurisdictional issue purely of law. But the district court was explicitly clear to JSP at sentencing, something as small as skipping school or smoking marijuana. And he says, I believe even specifically on conditional release, that could result in you getting this 20-year sentence, young man. And a full evidentiary hearing was held on the matter. And the findings of the court after that are what got us into the position that we're here today. We're not dealing with some capricious decision on the district court's part to revoke JSP's conditional release and sentence him to 20 years for no reason. It was a rather serious allegation that made him, for lack of a better word, mess up on EJJP and face the sentence that he knew full well he would receive.
Those are the issues subject to the appeal.
Those are issues subject to the appeal, and I haven't focused on that. But
Sure, I didn't mean
Certainly.
to, but...
But just so that the people at home know, I just don't want anyone to be under any misimpression that this was some sort of case where a 14-year-old just out of the blue gets a 20-year sentence that he didn't know was coming to him, when the judge and counsel and everyone was quite clear that this was what you're facing, and the underlying facts were they were very difficult. One of the victims was paralyzed for life. Even a 14-year-old can understand that there are consequences for that, and that this was, the EJJP sentence was his second chance. So fundamentally, though, I would just ask this court to affirm, unless there's any other questions that I need to address, I would ask this court to affirm the Court of Appeals decision finding that it lacked jurisdiction in this case. The long-held case law, DMT specifically, that all rights of appeal are statutory, and simply the statutes at play here do not confer appellate jurisdiction for JSP in the violation of his conditional release and the imposition of his adult sentence. I would ask this court to reject the appellant's argument, specifically that KSA 382347 operates to confer all of the rights that adult offenders have under the Criminal Justice Code, as that would render 382380 essential, and specifically subsection B meaningless. The legislature knew what it was doing. It chose to limit the rights of appeal, and we would ask that the court affirm. Thank you.
I just would like to briefly address some of the issues. One, the assertion that KSA 382347 renders 382380 meaningless or surplusage. I would argue that 2347 supplements the jurisdiction that is provided to juvenile offenders generally in 2380. And for good reason. EJJP offenders are subject to enormous sentences. To be an EJJP offender, you have to be first charged with a serious crime, and it almost always happens that a large underlying prison sentence is hanging over their head. With these facts in mind, the legislature, if we have to even ascertain their intent, we could reason that they intended to provide enhanced appellate protections for individuals who are subject to sentences that are adult sentences. And that not only are adult sentences, but there will always be serious adult sentences. And so I would argue that the plain language of 2347 is all you need to look at in conjunction with our criminal code, which provides a right for all defendants to appeal. If you need to go beyond that, I think it's not clear what the legislature's intent was, and I think that lenity should, be used to give the benefit to the defendant in this case.
I'm not sure I understand your meaningless, how that counters the meaningless argument being made. It's a Venn diagram, and so 2347's this big a circle, and the question is whether the more specific law is inside that big circle, and if it is, then it made that more specific law meaningless, is what the argument is. So how are you countering that?
Well, first, when we talk about the more specific statute, 2380 is the more specific statute as it relates to appeals versus, I would argue that it is not the more specific statute. I would argue that 2347 is the more specific statute, that which deals specifically with EJJP offenders, whereas 2380 deals with both EJJP offenders and juvenile offenders generally. And maybe I'm not answering your question.
Is there any point in having the more, what we're calling the more specific, if we give the interpretation to 2347 that you want to give it? It doesn't need to be there, does it?
Well, it vests jurisdiction in EJJP litigants for all adverse rulings.
I understood you to say a moment ago that mixing up my numbers here. I think it's, so 2380B applies to offenders that are not EJJP offenders.
Right, that applies generally to all juvenile offenders.
Therefore, it's not surplusage, at least with respect to those additional offenders.
Right, that is correct.
That's your argument as to why it's not surplusage.
Correct. And that's all I have, unless there's any other questions.
Are there other questions? All right. Thank you, counsel.